Someone was calling on your phone a minute ago. I assume we're ready to start?
I'll start recording.
Thank you very much. I'm calling to order a code enforcement hearing of the City of Cape Canaveral. Today's date is April 23rd, 2024. My name is Richard Geller, and the City Council appointed me to hear code enforcement cases pursuant to Article 6 of the City Code and Chapter 162 of the Florida Statutes. We're going to have two matters on the agenda this evening. Both are quasi-judicial hearings. The second of which is known as a Massey hearing, which I'll explain momentarily. In both cases, the burden of proof is on the city to show by a preponderance of the evidence that a code violation exists or with respect to the Massey hearing continues to exist. I will determine that based on the evidence presented to me this evening. Is it more likely than not that a violation has occurred? The alleged violator will have an opportunity to submit any rebuttal or exculpatory evidence, including testimony. At my discretion, I may allow a member of the public with relevant personal knowledge to testify, even if not called by either the city or the responding party. Anyone who would like to testify should sign the sign-in sheet where I'm indicating. And upon request, an alleged violator may ask relevant and material questions of any city witness. And likewise, the city may ask relevant and material questions of any witnesses for the responding party. I may exclude evidence that I deem to be irrelevant, immaterial, or unduly repetitious. In determining the amount of any fine, I will consider the gravity of the violation, any actions that the violator took to correct the violation, any previous violations committed by the violator as well. Under the City Code and the Florida statutes, I'm authorized to assess and order the payment of a fine of up to $250 per day per violation and up to $500 per day for a repeat violation. And in cases where the violation is irreparable or irreversible, a fine of up to $5,000, as well as the cost of any repairs made by the city in any case. At the conclusion of the hearing, I will issue findings of fact and conclusions of law based on the evidence of record and in order, both here on the bench and in writing. And I always endeavor to do that the same week as the hearing. The city will record a certified copy of any order that imposes a fine, and that order then constitutes a lien against the land where the violation occurs, as well as upon any other real or personal property owned by the violator. Any order that I issue may be appealed by any party to the Circuit Court for Brevard County, Florida, within 30 days. It is the responsibility of the appealing party to obtain a record of these proceedings for an appeal, and an appeal is limited to the record presented to me. The city's agenda packet will be administratively accepted into City's Exhibit 1 and its PowerPoint slides as City Exhibit 2. I have signed and approved the minutes from February 27, 2024, which was the last time that we met. And the next hearing date is May 28th, 2024. And I would ask at this point that anyone who expects to testify, if you would please be sworn in. Are you testifying? Stand up, please. Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you very much. All right, well, let's start with the first case on the agenda, case number 2023-263. The address indicated on the agenda is 190 Cape Shore Circle, number 5B. The property owners are indicated as John and Colleen Dunbar. I don't see Mr. and Mrs. Dunbar here. Have we seen them at all in the building?
They're not going to be here.
Okay. All right. Well, if you would just state your name and who you are for the record.
I'm Chris Robinson, City Cape Canaveral Code Enforcement Officer.
All right.
Like I said, this is in reference to 190 Cape Shore Circle. This is for installing a paver patio without a permit.
Okay.
The notice of violation was sent out on January 29th, 2024, and returned receipt on February 6th, 2024.
Wait, one second. You said it was sent out on, I thought I saw in the record that it was served on the 24th and then signed as received on the 26th. Did I get those?
I can double check the file here.
Let's just double check that. 'Cause I had some different dates there. Wait, I see notice of hearing. Where'd notice of violation go?
January 29th was when the notice of violation was sent out,
Okay,
and it was signed for on February 6th.
February 6th, okay. Just bear with me one second. I could have sworn I saw a different date. Yeah, January 29th, that's correct. Yeah, that is February 6th. Okay. Thank you.
Okay, the notice of hearing was sent out on March 18th, 2024.
Okay.
Return receipt, March 19th, 2024.
That's consistent with what I have. Okay.
This is the property in question. The green to the left is the river.
Okay.
7/20/2023, during patrol of the city, I observed paver pros vehicles in front of the building. Further inspection revealed a new paver patio was being installed without a permit and was almost complete. I contacted a resident in the owned unit and said they were just a tenant and asked them to have the owner reach out to me. 10/12/23, I've had no contact with the owner and no permit has applied for. A courtesy notice has been sent to the owner. On 10/18/23, the courtesy letter was signed for as received. 1/24/24, there has still been no contact and no permit obtained. A notice of violation was issued. 2/6/24, the notice of violation was signed for as received. 2/8/24, the owner came to City Hall and spoke with me about the notice he received. He explained he will get the permit taken care of.
Just if you keep that slide on for a moment, I just want to get some of those dates again. Oh, there we go. So it's 2/8/24. So and was that conference on the February 8th? Was that with you?
Yes, sir.
Okay. Was that Mr. or Mrs. Dunbar who you met with? Mr. Okay. Okay. All right. You can move on to the next slide.
3/14/24, there has been no application for permit as of this date. A notice of hearing has been sent. As of today's date, there has been no permit applied for. However, I did speak with Mr. Dunbar today. I guess there's some back and forth with him and Paver Pros
Okay.
about who's going to pull the permit. I think we established today that he's gonna go ahead and do it, and then
He being Mr. Dunbar?
Mr. Dunbar is gonna go ahead and do it. He doesn't seem to be getting through to Paver Pro.
Okay.
And then this is a photograph of them almost completed with the job.
Okay. And just looking at the eyeballing it, I mean, it doesn't appear there's anything wrong with the job. It's just they didn't pull the permit, right?
Yeah, I mean, looking at it, I don't think there's anything wrong. The biggest issue we have is because we're on a barrier island, we want to check and make sure that the shedding of water is going to be correct.
Okay. And then, meaning that there's sufficient space between the pavers for the water to percolate, is that?
Or that it's sloped so that it rolls backwards and not back into the house.
Okay. Well, that would be a definite health, safety, and welfare
could be
purpose for
suspicious.
that. Right.
There is no property representative here.
What's the city's recommendation on this?
We request until May 18th for him to comply with the notice of violation.
Okay, then if you have nothing further, I can.
No, sir, I have
let
nothing
me
further.
let me issue my findings here that I find that the respondents own the subject property based on the evidence of record in the agenda packet. That in July 2023, Paver Pros installed new brick pavers on the patio of the subject property at 190 Cape Shore Circle without obtaining the required building permit. That Officer Robinson spoke with the contractor and as well as with the respondent about the required permit. And as of today's date, a building permit has not been obtained. And because there's no permit, there have been no inspections. I find that construction work without a permit and inspections poses a danger to public health, safety, and welfare. Is there an issue with the business tax receipts? Is that still on the table?
No, sir.
Okay. All right. I find that the notice of hearing, the notice of violation, that all complied with the city code and Florida statutes for the service. I'm finding that there was a violation of the Florida Building Code, which is incorporated into the city code as at section 82-31. I find a violation of section 105.1 of the Florida Building Code requiring permits. I find a violation of section 110.1 of the Florida Building Code requiring inspections. We are not addressing the issue of the local business tax receipt. So I'm going to take that as not even presented to me. I'm not going to rule on that. And so we're going to have established a compliance date of May 18, 2024, to apply for and obtain the required building permit, arrange for and have a final inspection of the brick pavers. Do you want the application in by the 18th?
I want everything done by the 18th.
Okay, that includes the final inspection then?
Yes, sir.
Okay. If the respondent fails to comply within that time period, then I would direct Officer Robinson to schedule a compliance hearing before me and to duly notify the respondents, Mr. and Mrs. Dunbar, in accordance with law. And they'll have one final opportunity to appear and present testimony and evidence as to whether they have corrected the violation or whether it continues. And then I'll make a final determination at that compliance hearing, also known as a Massey hearing, whether the respondent has achieved compliance, and if not, I will impose fines. And upon a finding that the subject property remains in violation without the required building permits and inspections, I will issue a fine in an amount up to $250 per day per violation. And then, as indicated at the beginning of this hearing, any fines which I may impose upon the property will be a lien on the property in favor of the city. And if it is non-homestead real estate, I would point out that it is subject to foreclosure under Florida statutes, chapter 162.09, in which case the city could obtain an award of its costs, including reasonable attorney's fees. That's all I have for the Dunbar matter. And then let's move on to the second matter. This is a compliance or a Massey hearing, case number 2023-366. The address is 120 Jackson Avenue, and we have Randall Shane Reynolds as trustee, as property owner, and I see Mr. Reynolds is here today. So go ahead, Officer Robinson, you can take it away.
Yes, sir. Like I said, this is 120 Jackson Avenue. It's a Massey hearing. It's follow-up from a hearing that we had prior. The portion of the unsecured property, that part had already been taken care of. Okay. So we're here for the fire damage now. Okay. The magistrate orders were sent out.
So may I just interrupt you for 1 second? So there were my amended order in late January, it's January 24th. There were there were two sets of deadlines. One was January 28th, and that was to box off the staircase and to fix that fenced area.
Yes.
Okay, so that's all been taken care of?
That has been taken care of.
Okay. Okay, so then what we're dealing with now are the issues that we gave the deadline of March 8th, 2024, correct?
Correct.
Got it. Okay, I'll let you proceed.
So the magistrate orders were sent out on 12/13 and 23. I have a signature on the card, but there's no date when it was delivered. So I'd have to look up on the USPS site to see when that was delivered. The magistrate orders, that is.
Is it your testimony that there was delivery?
Yes, sir. I have the card right here. I can show that to you if you'd like.
If you could just give me so there's no.
There's no date on it.
Oh, I see. So we have a signature and no date. Okay, I got it. Deliver without a date. Okay.
Notice of today's Massey hearing was sent out on March 18th, 2024, and return receipt March 25th, 2024.
What about the amended order? Do we have?
This is the amended order right here.
I thought
that sent out.
Okay.
The original, we never sent that one out.
Okay, hold on 1 second. I thought I did the amended order in January. I thought the dates you just gave me were December. And take your time.
This one right here is the amended findings of fact. This is what I sent to them.
Okay, and the date you sent was December 13?
I signed, it said, yes, sir, December 13th.
Okay, 1 second here. I signed this, but I show that I signed, I have a copy of the amended findings of fact that I signed on, where'd that go? January 24th.
Yeah, January 25th is when I signed this right here.
What is that you're indicating?
This is the amended order. I signed it on January 25th.
Okay, what do you mean you signed it to, you mean putting it in
That
the
I
mail?
received it.
Oh,
It was
you-
given to me that I received it on January 25th,
Okay,
2024.
and I just want to make sure that it went to Mr. Reynolds. That's what I'm trying to
So,
establish.
Yeah, the cards that I have here are dated December 13th. So
Okay,
I don't have anything. I would have to go back through to see if I hand delivered it to him or not, or we would have to ask him if I handed it amended.
let me see if this is even an issue. Mr. Reynolds, could you come up to the microphone and just let us know if this is an issue or not? You just introduce yourself for the record, please.
Randall Shane Reynolds,
Okay,
the trustee of the property.
thank you very much. And then, did you receive my amended order that's dated January 24th that had the two sets of deadlines to get things done?
I couldn't find that. I was looking around for it, but I didn't find it.
But was it delivered to you?
Yes.
Okay, it was delivered to you. Okay, so you're not, there's no dispute that you got it. You may not be able to find it before today, but you'd got it at some point.
Yeah, I'm here today and
Okay.
got this one too.
Okay, I appreciate your honesty. Okay, thank you, sir.
Actually, I believe, Your Honor, this was, I met with Mr. Reynolds to go over the original information, the first deadline that we had for him to inbox in the staircase. And we went out there and I handed him the amended copy at that time. So
Right.
I apologize, I have
No,
my
that's okay.
certified letters from, or certified notification from the original one.
I don't think it's an issue because I orally gave these deadlines here at the hearing, and then he testified that he did receive it at some point. So I think we're okay.
Okay, you got when the notice, you have those
Yes,
dates?
yes, to the best of my ability. Okay.
And then again, this is the property in question off of Jackson Ave. The compliance hearing was conducted to see if the property was in compliance with the magistrate orders. It was determined that the garage and storage room under the stairs were boarded up in compliance. The staircase it determined more needed to be done to satisfy the city's concerns. The property owner was given until January 28th to comply with the new orders. On the 29th of January, site inspection found the staircase has been enclosed with an 8-foot wall, and the department director, Dave Dickey, as well as the city manager, Todd Moley, have agreed the wall is sufficient. 3/11/24, a site inspection revealed no work has been performed to repair the fire-damaged room or roof. No permits have been applied for at this time. A Massey hearing will be scheduled.
Okay, if you just keep this slide up so I can get this information. All right, you could proceed. I got it.
And then on 3/18/24, the notice of compliance hearing was generated and sent to the property owner.
Okay.
Here it is, boarded up, per your requirement.
And it looks good.
Oh, yeah, that portion of it is fine. We were good to go with that.
Yeah.
Now, there's been no activity with the fire damage that was
Okay.
supposed to be done by March 8th. So he was supposed to repair all damage caused by the fire on the subject property, repair or replace the garage door so that it's functional, rebuild a new staircase in compliance with the city code with secure guardrails, install guardrails on the roof balcony outside the upstairs residence unit, and continue to secure and prevent the property for upstairs units and utility closet to be utilized by unauthorized persons. Nothing has been done. There's been no permits pulled. There's been no fire damage repaired or anything. I have spoken to Mr. Reynolds, and he'll be able to testify to that more.
Okay.
The property is in the process of being sold to somebody else.
Okay.
I spoke to that person. I guess there's some competition, and Mr. Reynolds can probably clarify it, some competition between who's going to purchase the property between two parties. One party has a closing date, I believe it's in June. If the other party doesn't match or beat it or whatever the circumstances are. So that's where we're at with it. So I think that might be why we are delayed on some things right now.
So, well, I'll hear from Mr. Reynolds, but it seems to me that if someone's willing to buy the property, and I mean, they're buying the issue, they're,
Correct.
okay. All right, Mr. Reynolds, what's going on? What say you?
Well, that's, the lady that was here last time we had court. I guess you remember she had a few, problems with me and stuff like
Yes.
that. She's one of the buyers. And so.
One of the potential buyers.
The potential buyer. And like I said, I just don't have the money and stuff
Okay.
to do any of the fire damage and stuff. I had an investor and stuff that was going to do it, but he backed out. And so now I'm just trying to sell it for bare minimum because I don't want to get in trouble with you guys. So,
Okay.
I'm just going to sell it as is. And Peg knows about that, and also Vincent Kean, the realtor that was going to buy it.
Okay, so who are the two potential buyers?
Vincent, what is it, Keenan? Keenan. He's a realtor around here
Okay.
and has the Moon Hut.
The,
And so
the
I
Moon Hut,
called-
is that a restaurant or a
Yes,
bar?
Moon Hut right here.
Okay, Vincent
It's
Keenan.
right next door to my property.
Oh, okay. And then the lady who was here is the other potential buyer. What was her name?
Peg,
Schaller, Schaller.
So, with which of these two potential buyers do you have the closing dates set up right now with?
with Vincent.
Okay.
And that's on June 18th or somewhere like that, 8th, 9th.
June 8th or 9th.
Yeah.
And so if he does not close, then it is your intention to then sell it to Peg?
Yes.
Is that the deal?
If she matches the deal, she gets to buy the property and stuff. It's in a lease that I have with her.
Oh, okay, so she just has, and then can I ask, what's the price that you've contracted to?
$650.
$650,000 to sell the property, and then that's with Mr. Keenan. If Ms. Schaller matches that, then she has, I guess, a right of first refusal, I guess?
Yeah, that's it.
Okay. Okay. So now, from the city point of view, do you know anything about Mr. Keenan's plans or Ms. Schaller's plans with respect to what they would do once they would buy the property?
I spoke to Vincent Keenan.
Okay.
I can't speak for Ms. Schaller and what her intentions are. I would assume it would be the same as Mr. Keenan's is to fix. Mr. Keenan said he was going to fix the property up, maintain all current tenants, and continue to rent it out.
Okay.
I would assume Peg Schaller would be now the owner and she would fix it up.
Okay. So, I'm just thinking out loud here, but from the city's point of view, you don't want to necessarily do anything that's going to interfere with them getting the property, but you do need.
Well, I spoke to Mr. Keenan and advised
Yeah.
him that there would likely there'd be a lien on the property.
Okay.
So the city still wants to move forward with that,
Okay.
and then we can revisit that down the road if compliance is achieved.
Okay. Mr. Reynolds, anything else you'd like to add before you step
No,
down?
sir.
All right, thank you. So what is the recommendation of the city as far as,
Based on the testimony and evidence submitted at this hearing, staff respectfully request the magistrate find the respondents in violation of the magistrate orders and impose a fine beginning March 8th, 2024, in the amount of $200 for the first day and $150 every day thereafter until compliance is confirmed by the code officer.
okay, so beginning March 8th, and the first day is how much again?
$200,
$200. And then after that,
$150.
$150. So let me just think about this for a moment. So if there's Mark, so about 3 months of fines, assuming it sells on June 8th. So this is just a very rough calculation. So if the property were to sell on June 8th, the contract were to close, the fines would be somewhere around $13,500 at that point. And then, so the new owner could then present himself or herself to me and ask for a recommendation of some leniency on that or to strike it. And then, and would then go to the city council.
If they're in compliance.
If they're, yeah, assuming, yeah. So that's, exactly. So assuming they make the fixes, then they can come ask for the forgiveness or the reduction of the fine.
Our contention is that this is a life safety issue.
Yeah,
All parties agree that it's a life safety issue. So we don't want to just let it go. We want to kind of have the fire under some people's feet who purchase it, that when they buy it, they need to get on this as soon as possible. It needs to be a priority.
right. I don't disagree with that. Okay. And when you spoke with Mr. Keenan, he wasn't going to back away from the deal when you told him that there were going to be some fines issued. I mean,
He didn't give me that indication. He felt he was going to buy it as an investment.
right. He's going to fix it up, and it'll then be worth a lot more than $650, assuming
He can fix it up and retain the current tenants, because that makes him money.
Right. Okay. All right. Okay. I just wanted to make sure that we weren't going to destroy the deal. It doesn't sound like it. I mean, this is in the big scheme of things. Let's say it takes 6 months to get done, and let's say that the fines are $25,000, if doubling, a little less than doubling what I just calculated. That's minor compared to the $650 that he's going to be spending to purchase the property. Okay, then I'm comfortable with where we are then. So, all right. Well, I'm gonna issue an order imposing fines and a lien. And so my job here today was to determine whether the property remains in violation. I find that property does remain in violation. Certain things I've heard arguments, I've heard evidence and testimony in accordance with Massey versus Charlotte County, 842 Southern 2nd 142, 2nd DCA 2003 case. I find that I issued amended findings of fact, conclusions of law and order on January 24th, 2024, and ordered Mr. Reynolds to get the property into compliance with the city code by two different sets of deadlines. The first, January 28th, 2024, was to secure the staircase with it being boxed out. And that was accomplished, as well as the fixing of the fence issue. There was a gap, and I heard no evidence that that's not been fixed. Then the second set of issues to be corrected for a deadline was March 8th, 2024. That was to repair all the fire damage caused by the fire of the subject property. I find that was not done. The garage door was to be repaired or replaced so it would be functional. That was not done. The staircase would be rebuilt with secure guardrails in accordance with the city code. That was not done. Guardrails on the roof balcony outside the upstairs residential units was not done. And that there would be continued prevention of occupancy of the upstairs units. That's really not an issue right at this moment because that box still exists. So I do find that the service of the January 24th, 2024 amended order was served and delivered on Mr. Reynolds. That the notice of hearing was also appropriately delivered, and Mr. Reynolds appeared here today to explain from his point of view where things stood. So I do find compliance with the service requirements of the city code and the Florida statutes. I'm going to find continued violations of section 108.1 of the International Property Maintenance Code. That's when a structure is unsafe or unfit for human occupancy. Violation of, let's see here, section 302. 302.1 of the Property Maintenance Code. Exterior property and premises shall be maintained in a clean, safe, and sanitary condition. I don't find that that's the case with all the fire damage. Continued violation of 304.1. The exterior of a structure shall be maintained in good repair, structurally sound and sanitary so as not to pose a threat to public health, safety, welfare. Find a violation of 304.11, unsafe conditions, which requires any building determined to be unsafe to be repaired and replaced to be in compliance with the International Building Code and the Florida Building Code. I find violations of 304.2, which is the protective treatment on the exterior surfaces of a building, simply because the fire damage has not been fixed. That violation continues to exist. Same with 304.6, which governs exterior walls. Same with 304.7, which governs the roofs. Again, because of the fire damage that continues to exist. The 304.10, finding violations of that with respect to the balcony. 304.12, continued violations because the guardrails and handrails have not been installed as ordered. The continued violation of 304.15, which governs exterior doors, and the garage door was brought to my attention. Continued violation of 306.1, components of a structure and equipment thereupon shall be maintained in good repair, structurally sound, and in sanitary condition. I don't have evidence about equipment, but the structure itself, I find that to be continued violation. I find continued violation of 306.1.1, which deals with unsafe conditions, which includes fire damage beyond charring and inadequate support. I find continued violations of 307.1, governing handrails and guardrails on flights of stairs simply because well, we have a box, but we don't have a completed stairwell. And so I'm finding continued violations of my original order dated December 11, 2023, as amended on January 24th. I'm going to issue an order imposing a fine in the sum of $200 for the first day, March 8th, 2024, which was the ordered compliance date, and then $150 per day there. Until the property is brought into compliance with my order, both orders. For the record, in setting the fine, I considered the gravity of the violations, the risk to public health, safety, and the fact that it continues to be a nuisance to the occupants, the other occupants of the property. I appreciate Mr. Reynolds not having funds available to correct the violation, but unfortunately, we just haven't had any correction, and so I just don't have a real mitigating set of facts here to fix on the part of fixing the fire violations, fire damage violations. There's no evidence of any prior violations by Mr. Reynolds. I don't think this was intended on his part at all. It's just the unfortunate circumstances of what we have. Again, any these fines will be recorded. It will become a lien on the city, on the subject property, and on any other real or personal property of Mr. Reynolds. And there will be the authority of the city to foreclose on the property after at least 3 months has run from the date the order is recorded in the public records of Brevard County, Florida. To stop the accrual of fines, the respondent or whoever purchased the property has an obligation to advise the city Code Enforcement Division that the property has been repaired, and to obtain all necessary inspections and to apply for all necessary building permits. I find that this does not appear to be homestead property. You live there?
I don't live there now because of the fire, but did before.
It's not a homesteaded property. It's commercial property.
Correct.
Homestead with me and my dad.
No, there's no homestead exemption on it.
Yeah, I am. Were you residing at the property?
Not at the time of the fire, no.
Not at the time of the fire? Okay, or after the fire? Yeah, obviously not. So, yeah, I don't think it's your homestead. Do you claim homestead on another property?
No,
He,
no, just, I was told that it was homestead from my father and stuff and passed on to me in the trust.
you might want to get with the Brevard County property appraiser and make sure that you claim whatever homestead you're entitled to for wherever you're living permanently. If you own where you're living, you should check into that.
Can there be any lenience? Can I come up?
Sure, you can come up. Yeah, there can be a lien on homestead property. However, the city would not foreclose on homestead. And so I think the intention here is this property gets sold off within 3 months. They wouldn't even be able to begin foreclosure proceedings for 3 months anyway. And so if the seller, Mr. Keenan or Ms. Schaller, whoever it is, you know, they ought to hit the ground running and get contractors out there right away and start getting this stuff fixed. It would be my,
They would have the finances to do so, but, what about the different things that I was told, you know, the different things that I put up, that way nobody can get up to the burn area and have it all blocked off and stuff
yeah,
like
there,
that?
I found compliance.
And so, I mean, financially, is there any way we can go into a little bit longer, like from now, the date today? On the fines? From
no, with
going
the-
back to March?
Well, the compliance deadline was March 8th.
Yeah,
And so that's where where the fines are supposed to begin. At the, you know, if compliance is not done by the compliance deadline, that's when the fines start happening. You know, I would look upon favorably if the new owner gets in there with, you know, right away and they hit the ground running and start getting bring this property into compliance. They can come to me and ask for a reduction or forgiveness of the fines and any lien that may have been recorded, and I can make a recommendation to the city council at that point. So that's their ability to do that.
yeah, it's kind of scary.
I know,
I mean,
it is.
It's just, I had with Vincent, it would already been sold as we speak right now, but on the clause, Mrs. Peggy Schwartz,
Or Schaller.
she gets, due diligence. So in the contract, we did the 90 days, she's trying to push it even further than that. So I don't know how long, that she's wanting to push it back a couple more
Yeah.
months. So that's what I'm kind of worried about.
And can I say something
You
real quick?
can.
And the city takes that into consideration when they come back for the reduction. It's what we look at as a city is when somebody, once they purchase the property, not the length of time it takes to purchase the property, but once they do purchase the property, it's the length of time they bring to bring the property into compliance. If they show good faith and they immediately start with the process and getting the permitting and stuff like that, the city looks favorable on that, and then we bring it in front of the magistrate, and then we would ask the magistrate that we would accept the reduction, but I can't say anything for right now until I see, you know, what they're gonna do once they purchase the property. But that's the main thing we have to look at is they do have the option to come in and ask for that reduction or relief of the whole lien.
Yeah, okay. And I was just finishing up my order from the bench, and I'll get that all in writing this week again. I don't recall anything else on the agenda. Anything else the city would like to present? Okay. Thank you, everyone. We'll call it adjourned. Thank you.